We're muted.
There we go.
All right, we're
I can
muted.
hear.
There we go. I'm sorry.
Okay,
I'm the one that's
perfect.
muted.
No problem. I was like, what am I doing wrong?
All right. Good afternoon, Mr. Cabrera. Which is your case?
My case is the 19th on the docket. It's Discover Bank versus Omar E. Davila. It's a default.
Okay. Yes, sir. CL 21-2301D, right, sir?
Yes, sir. Yes, Your Honor.
And you represent Mr. Davila?
I represent Discover Bank.
I'm sorry, Discover Bank. Okay. Let's put here Mr. Cabrera. Okay. Is that the only case you have?
That we had one scheduled to on the docket. It was the 20th, but they filed an answer, and so we called to cancel it.
Okay. I have another Discover Bank here versus Mary Lou Cantu, number 12.
No.
I don't know if that was yours or not.
No, it's not. I only had two. It was the 19th and the 20th on the docket. Yeah.
Okay. Should we start with him so we can get this another way? All right. Let me do your case first, Mr. Cabrera.
Thank you.
Because otherwise you're gonna wait 3 or 4 hours, and I don't want you to wait. I don't want you to wait that long.
Thank you.
Court will resume with the April 6th, 2022 docket, and we're on YouTube here. And the first case I'm going to call is CL 21-2301, the Discover Bank versus Omar Davila. Court will note that Omar Davila is not in the waiting room. Therefore, court will take judicial notice of the entire file. And Mr. Cabrera, you may begin, sir.
Thank you, Your Honor. This motion for default judgment stems from a breach of contract suit filed June 23rd, 2021. The defendant was personally served September 24th, 2021. The last payment on the account was August 13th, 2020. It was charged off May 31st, 2021. We send a notice of this default hearing by first class mail on February 28th, 2022. There's no answer on file, Your Honor, and we believe that Discover is entitled to a judgment of $13,872.20, 5% post-judgment interest, and court costs of $370.15.
All right. Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will therefore wait for a default judgment for signature. Anything else, Mr. Cabrera?
No, Your Honor. If you don't have one, I can e-file it this afternoon if you don't have an order.
Well, yeah, please check. If there's one, just leave it alone.
Okay. I'm pretty sure we sent one. I'm pretty sure.
Okay. Thank you so much. Have a great afternoon, and watch out for the hot weather. We got hot weather right now. 108 while ago.
It's 96 in Round Rock, so it's hot. It's
108 as I was driving a while ago. So be careful out there, okay?
Thank you, Your Honor. Thank you for moving me up. I appreciate it.
Yes, sir. Bye-bye.
Bye-bye.
Mr. Kettler, right?
Yes.
Mr. Kettler, good afternoon, sir.
Good afternoon, Judge. Good to see you again.
Good to see you again, sir. You want to bring in Lady Ellis right now?
Give him the case.
Okay, yeah. There's this person that's in the waiting room, and only one person only. That'll be CL 18-2908D, which is our number 3 here. Portfolio Recovery Associates LLC versus Lady Ellis. Let me just see if there she is. She's connecting right now. All right. Do we have her now, Ida? Or we need audio?
She needs audio.
Yeah.
She's connected. We can do number 1 while she.
Okay, we need audio. What we're gonna do is proceed with number 1, and then oh, there she is. I think she's already.
Yeah, she needs to unmute.
Okay, you need to unmute Miss Alice.
Oh.
All right. Good afternoon. Yes. Good afternoon. Can you hear me, ma'am?
Yes.
All right. Good afternoon. You're here on CL 18-2908D Portfolio Recovery Associates LLC versus Lady Ellis. You don't have an attorney, Miss Ellis?
No, sir. I was just given the letter yesterday's stamp that it left, so I just received it today. So I wasn't aware.
Okay. Have you by any chance been communicating with the companies, with the creditors?
No, sir. Like I said, I didn't have any knowledge.
Okay. What we're gonna do here is because you're here in person, we're gonna give you a phone number so you can contact them and see if you can work it out or settle it. Okay, ma'am? You have a pencil and paper so you can write the number?
Just give me a little bit because I just had surgery.
Oh,
So I can't move as fast.
okay. Be careful there.
Es el juez. El juez. Nomás que dice que me va a dar un número.
Yes. And Mr. Keller, do you have some phone numbers?
I do.
Oh, is it the same one?
It's the same two, Judge.
The same two? Okay, we got it. We got them.
Okay, thank you.
We got them. I think we can read them out. Let me just make sure she gets paper and pencil and give her an opportunity.
Yes, sir.
All right, here are the numbers. They're going to be two numbers. Okay, ma'am? Okay, the person is Miss Megan Hale, Meganhale, Hale, 262-796-7890. One more time, 262-796-7890. And there's another number, 866-456-3744. 866-456-3744. Give her a call, see if you can work this matter out, but in the meantime, we'll set it for status hearing. And Mr. Kettler, submit an order, please, for status, and we'll give you another date, then we'll just combine it with the other case.
Got it, Judge.
We'll set it for status hearing. We'll notify Ms. Ellis and see how it went with her settlement negotiations. Okay, Ms. Ellis, so there'll be no action taken today, okay, ma'am?
Okay, would there be another court date? And then,
Yes, there's going to be a status hearing, and we'll notify you about that one later on,
okay,
okay?
thank
Hope you
you.
get better, okay? Hope you feel better.
Thank you.
All right, thank you, bye-bye. Okay, ready to go? All right, Mr. Kettler, number one, CL 18-1951D, Portfolio Recovery Associates LLC versus Margarita Mora. Court will note that Margarita Mora is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Yes, Judge. This is a plaintiff's motion for default arising from a debt claim. After a period of non-payment on the account, it had been charged off and assigned to plaintiff. Today, plaintiff is seeking judgment in the amount of $1,523.78, reflecting a credit of $400 post-suit. They're also seeking costs of court, but are waiving post-judgment interest or attorney's fees.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. Next case, CL 18-2897D, Portfolio Recovery Associates LLC versus Diana Sanchez. Court will note that Diana Sanchez is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Yes, Your Honor. This is plaintiff's motion for default arising from a debt claim, debt buyer case. After a period of non-payment, the account had been charged off, assigned, and sold to portfolio recovery. And today they're seeking judgment in the amount of $1,793.31 plus costs of court.
Court will grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. Then we go to number 4, CL 18-3316D, Portfolio Recovery Associates LLC versus Michael Medrano. Court will note that Michael Medrano is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Yes, sir. This is also plaintiff's motion for default arising from a debt claim. After a period of non-payment, the original creditor charged off, assigned, and sold the account to plaintiff portfolio recovery. And today they're seeking judgment in the amount of $3,446.95, reflecting a credit for $204. They're also seeking costs of court, but no post-judgment interest or attorney's fees.
Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. CL 18-3377D, Portfolio Recovery Associates LLC versus Aide D. Peña. Court will note that Ms. Peña is not in the waiting room, so therefore court will take judicial notice of the entire file, and you may proceed, sir.
Yes, Judge. This is plaintiff's motion for default arising from a debt claim. After a period of non-payment, the original creditor charged off, assigned, and sold the account to plaintiff. Today, they're seeking judgment in the amount of $4,505.70. That's 4505.70, plus all costs of court and no post-judgment interest or attorney's fees.
Okay, court will grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in his petition. Court will await a default judgment for signature. Next one, CL 1835-14D, Portfolio Recovery Associates LLC versus Miguel Alvarez. Court will note that Mr. Alvarez is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Judge, with this one, there's a little bit of special handling. It's my understanding that a tentative settlement agreement might have been reached, and accordingly, we're respectfully requesting a reset of approximately 60 days if agreeable.
We'll do a status hearing. No action taken today. And
Judge, for the record, there was a motion for continuance e-filed by plaintiff on April the 1st, 2022.
okay, thank you, bailiff. So we'll take no action and also set it down the line. Okay, we'll do that. CL 1835-64D, Portfolio Recovery Associates LLC versus Francisco Araujo. Court will note that Araujo is not in the waiting room. Therefore, court will take judicial notice of the entire file. You may proceed.
Yes, Judge, this is plaintiff's motion for default arising from a debt claim. After a period of non-payment, the account had been charged off, sold to portfolio recovery. Accordingly, plaintiff is seeking judgment in the amount of $1,126.01 plus all costs of court.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in his petition. Court will await a default judgment for signature. Next one, CL 1837-38D, Portfolio Recovery Associates LLC versus Domingo Loevano. Court will note that Domingo Loevano is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Thank you, Judge. This is plaintiff's motion for default arising from a debt claim. After a period of non-payment, the account had been subsequently charged off, assigned, and sold to plaintiff portfolio recovery. Today, they're seeking judgment in the amount of $1,093.08 plus cost of court.
Court will grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. CL 1837-95D, Portfolio Recovery Associates LLC versus Maria Martinez. Court will note that Martinez is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Thank you, sir. This is plaintiff's motion for default arising from a debt claim. After a period of non-payment, the account had been charged off, assigned, and sold to Plaintiff Portfolio Recovery Associates LLC. Today, they're seeking judgment in the amount of $2,926.70 plus all costs of court.
Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. All right, CO 1838-31D, Portfolio Recovery Associates LLC versus Victor Garza. Court will note that Mr. Garza is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Thank you, Judge. This is plaintiff's motion for default arising from a debt claim. After a period of non-payment, the original creditor charged off, assigned, and sold the account to plaintiff. Accordingly, portfolio is seeking judgment in the amount of $2,119.26 plus costs of court.
Court will go ahead and grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. CL 1840-18D, Portfolio Recovery Associates LLC versus Jorge J. Torres. Court will hereby note that Mr. Flores is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Thank you, Judge. This is plaintiff's motion for default arising from the debt claim after a period of non-payment. The account had been charged off, assigned, and sold to plaintiff. Today, plaintiff is seeking judgment in the amount of $1,511.72 plus costs of court.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court, and court will await a default judgment for signature. The next one is the Discover Bank case. Is that yours?
Yes, Judge.
Okay. CL 184117D, Discover Bank versus Mary Lou Cantu. Court will note that Ms. Cantu is not in the waiting room. Therefore, court will take judicial notice of the entire file. You may proceed, sir.
Yes, Your Honor. This is plaintiff's motion for default arising from the debt claim. More specifically, Discover Bank is the original creditor, and the underlying account was a Discover More card. After a period of non-payment, the account was subsequently charged off, and Discover made the determination to pursue this outstanding amount. Today, Discover is seeking judgment in the amount of $1,849.93 plus costs of court in post-judgment interest at the current lawful rate of 5.0%.
Will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. CL 1843-14D, Portfolio Recovery Associates LLC versus Miguel Salinas. Court will note that Mr. Salinas is not in the waiting room, so therefore court will take judicial notice of the entire file, and you may proceed, sir.
Thank you, Judge. This is plaintiff's motion for default arising from a debt claim. After a period of non-payment, the account has been subsequently charged off, assigned, and sold to plaintiff. Today, they're seeking judgment in the amount of $3,864.24. That's 3864.24 plus costs.
All right, court will hereby grant default judgment in favor of plaintiff, and court will grant plaintiff all relief requested here in open or in its petition. Court will await the judgment for signature. CL 1843-93D, Portfolio Recovery Associates LLC versus Tomas Barrientos. Court will note that Mr. Barrientos is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Judge, this is also plaintiff's motion for default arising from a debt claim. After a period of non-payment, the account has been charged off, assigned, and sold to plaintiff. Today, they're seeking judgment in the amount of $814.73 plus costs of court.
Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. CL 1852-32D, Portfolio Recovery Associates LLC versus Laura Morin. Court will note that Ms. Morin is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Yes, Judge. This is plaintiff's motion for default arising from a debt claim. After a period of non-payment, the account has been subsequently charged off, assigned, and sold to plaintiff. Today, plaintiff is only seeking judgment in the amount of $423.53, reflecting a credit of $284, as well as costs of court.
All right, court will hereby grant default judgment in favor of plaintiff. Court will also grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. I think
Number 16, there was a non-suit.
number 16, this one is going to be a non-suit was already signed and granted on this one.
Yes.
It's CL 1700D, Portfolio Recovery Associates LLC versus Cecilia Villarreal. This is where we have an order of granting notice of non-suit signed. Do you see that, Mr. Kedler?
I do show that in the registry, Judge.
Okay. Then we'll skip that one.
Understood.
We'll go to CL 191729D, Portfolio Recovery Associates LLC versus Sully Villarreal. Court will note that Villarreal is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Yes, sir. This is plaintiff's motion for default arising from a debt claim. After a period of non-payment, the account had been charged off, sold to plaintiff. Today, portfolio is seeking judgment in the amount of $1,609.05, which reflects a credit of $76, as well as cost of court.
Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested hearing open court or in his petition. Court will await a default judgment for signature. Let's see, we have here CL 1966D Portfolio Recovery Associates LLC versus Diana A. Martinez. Court will note that Martinez is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
Yes, Judge, this is plaintiff's motion for default arising from a debt claim. After a period of non-payment, the account had been subsequently charged off, assigned, and sold to plaintiff portfolio recovery. Today, we're seeking judgment in the amount of, excuse me, of $550. Excuse me, I got a little choked up. 1 second, I need to get the water.
Okay, you're muted. There you go.
Thank you, sir.
All right, there you go.
Yes, we're looking for judgment in the amount of $550.50 plus cost of court.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court and or in this petition. Court will await a default judgment for signature. And I think the last one here is going to be CL 21-2831D Goldman Sachs Bank USA versus Jose Mendoza. Court will note that Jose Mendoza is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed, sir.
And
Judge, for the record, there's an answer on file.
All right, bailiff, you said there's an answer on file?
Yes, sir. That was filed on April the 4th, 2022.
April 4th, 2022. April 4th, 2022. Did you get that, Mr. Kedler?
I did, Judge. I think that belonged to the previous attorney, the one who only had the one case.
Oh, Cabrera?
Yes, sir.
Okay. Yeah,
I think-
no action will be taken in this case anyway. We'll just leave it alone. But I think as far as all your cases, sorry.
Are we talking about the same case
Okay,
or is it number 20?
Number 20, let me see here. Let me see.
Because the one that Mr. Cabrera made an announcement is number 19.
Right. Mr. Cabrera made an announcement on Omar Davila, CL 21-2301D, Discover Bank versus Omar Davila. Remember, that's the one Mr. Cabrera appeared on. And then I asked him if he had any more cases. He said, no, I don't have any more.
I think I remember you mentioned something about the 20th on the docket, having an answer on file at the very beginning of the hearings. But at any rate,
Yes, he did.
Okay,
Yes, he did say that.
great memory. You got it. Yes. I've checked with my computer. Yes, that's what he says. So that's it for Mr.
That's it. Yes, sir.
Wow, that was quick, Mr. Kedler. In the morning and the afternoon, 2 quick sessions here. Anything else, Mr. Kedler?
nothing further today, Judge. May I be excused?
Yes, sir. You have a great day. Stay safe, okay?
Y'all too. Take care,
You too.
please.
But you take care. Bye-bye.